On the record in the matter of Folly Property, Michigan versus Erica and Larissa Odell, or Odell, file number 23-00886 LT. Appearance, please.
Thank you. Good afternoon. Sam Dua here on behalf of Tenant.
Your name? Okay. Okay, today was the date that we set this matter for hearing, and Eric is deceased, correct, ma'am? Okay, it was the hope that the parties would be able to resolve this. The parties have been unable to resolve this matter?
Correct, Your Honor.
Okay. This is an eviction for non-payment of rent,
Correct, Your Honor.
possession only. Okay, and Miss Odell or Arnold? Odell, okay. Do you believe you have a lawful reason to withhold this property?
No, I just asked for 30 days to be able to relocate my kids and I.
Okay, and so that's the disagreement, was the time frame for the vacate?
Correct, Your Honor.
Okay, and so you're asking for 30 days, but you're not able to make any rent payment or anything of that nature, correct?
I can get someone now. Before I didn't have any life insurance money or anything.
Okay, that your client's not willing to take the past due rent?
I don't have that much.
Oh, you don't have that much, you're not
No.
able to pay in full?
No,
You just are trying to seek to pay moving forward?
so that I can have 30 days at least to relocate.
Okay, and you've secured a place to stay?
No, ma'am.
Okay, and so you are requesting 30 days to vacate, and your client only wants to give the statutory 10 days?
Your Honor, if I may pause you for just 1 second, is there a Foley, gentleman, last name Foley in the waiting room on the Zoom? One of the plaintiffs may be on Zoom.
No one's in my waiting room.
Okay, great, thank you. Your Honor, if you may recall, the original pretrial of this was on May 10th, and then on June 21st, we were here again, and the plaintiffs voluntarily granted that adjournment for the additional time in order for the remaining defendant to get her affairs in order. So unfortunately, at this time, plaintiff feels that they've already given that time in order for her to do that, in expecting a different result today.
Was the expectation that they were gonna pay in full, is that the expectation?
Or vacate.
Or vacate, okay. Ma'am?
On the May 10th, my husband and I both were online. There was a payment arrangement that was secured. My husband did make a payment to them, the payment arrangement, I believe it was $2,000. On the 15th, he had passed away and he was the only source of income. So when we came into court on the 21st, I think is what.
Of June?
Yes, the 21st, I had absolutely no idea what was happening or what I was going to be able to get. I didn't have the death certificate yet.
When did he pass?
May 15th,
Okay, so shortly after the first hearing,
yes,
and you said there was a payment arrangement at that time?
on the 10th, yes,
What was that payment arrangement?
$500 a week extra on top of the normal rent.
Okay, so he made one payment of $2,000?
I don't have the record of it, I'm sorry.
Your Honor, I have the ledger if I may approach. It's already been marked as Exhibit 1 if you'd like to see it.
Yes, please.
The ledger will show, Your Honor, that there was a $2,500 payment made 7 days before the pretrial and nothing made after, I presume, because of the unfortunate situation that happened to the plaintiff.
According to this ledger, there wasn't, rents are past due almost since a year ago, correct?
Correct, Your Honor.
Okay,
It was actually a case filed back last February with a different plaintiff's attorney, and plaintiff's attorney was not present, so the case got dismissed. This likely would have been resolved prior to the death of Mr. Odo, but that case was dismissed.
okay. And so why weren't you all paying your rent up until, or prior to his being deceased?
Laid off from work, he worked for the IBEW local in Lansing. And he was laid off, and so he got in with MSU, and then he had pretty steady work at that point.
Okay. And
I
then,
was looking for help through any agency that we could get it through. There wasn't a whole lot that was available.
okay. Well, this is an unfortunate situation, but the reality of it is you're not providing me with a lawful reason why you should be able to withhold their property for an additional 30 days. This is an eviction that's been proceeding, at least your first court date being back on May 10th. We're now at the tail end of July, or at least the middle of July, with today being July 19th. And I think that the last adjournment was because the plaintiff thought that you all, or you would be able to get money to pay the past due rent. That's the only way I think it would be reasonable for you to be able to withhold this property. They haven't gotten rent for almost a year on this file, on this property. And it's not because they didn't do their job as the landlord. That's not what's being alleged here. And so that's not fair to the landlord. You have to provide the court with a lawful reason why you believe that you can withhold the property. And so with that being stated, judgment will be entered in favor for possession only as to the plaintiff. And there will be a writ date, which is statutory standard. What's the writ date? July 31st. Is the writ date. Now you and the plaintiff are free to negotiate further about that date. If that's the case, then you can file something with the court. But the writ date, they're free to request a writ to execute the eviction on or after July 31st. This is yours.
Thank you. May I approach with that order?
You may. Oh, any additional matters for the record today?
Nothing from plaintiff, Your Honor. Thank you.
Do you have any questions today, ma'am? Oh, good luck to you, ma'am. Thank you.
Consent judgment for Morgan.
There's green.
Sent Morgan.
230.
Thank you, Your Honor.
Thank you. On the record in the matter of Huron Development LLC versus David Harris Green, the file number is 23-00946.
Good afternoon, Your Honor. Joe Joseph for the plaintiff.
Good afternoon, Your Honor. David Harris Green for the defendant.
Thank you. Today is the date and the time that's set. Let me stop her video. For a hearing, how are the parties proceeding?
Thank you, Judge. We've worked out a consent judgment here. It's a consent judgment for possession with $4,395 that's due, plus cost of $165.82. That brings the total claim to $45.60.82 with a writ to issue after August 4th. I've gone over Mr. Harris Green's statutory rights under 4.201 regarding the 3-day rescission rule. He's also consented to having me sign his name to this agreement as well.
Okay, you said the amount past due was $4,395
Correct.
plus 162 for court costs.
Yeah, 165.82.
165.82. For a total of $4,560.82.
Yes.
Okay, and when is the vacate date?
August 4th.
Okay, Mr. Harris Green, is that a complete and accurate understanding as to how you want to resolve this matter with a conditional dismissal? I'm sorry, with a consent judgment?
Yes, I am aware that I do have 3 days where I can appeal it.
Okay, so you want to enter judgment today by consent?
Yes.
Okay, so you have the right to have an attorney represent you at this proceeding, and you were advised of that right back at your pretrial, but you did appear without counsel today, so you're waiving your right to counsel today?
Yes, ma'am.
Okay, and you have the right to have a hearing on this matter or a trial to determine whether or not you could lawfully have judgment entered against you. Are you willing to waive your right to hearing and trial in this matter?
No.
You're not willing to waive your hearing?
No, ma'am.
Okay, well, we're proceeding right now, if that's what you want to do.
Okay. Yes, I did speak with the attorney, giving that I do have an ongoing domestic violence case where I'm a victim of. I believe you are the judge overseeing that case in a different matter. I did inform him that at the time when the pretrial date was scheduled, I was on FMLA. I recently started a new job with the U.S. government that I started training on the 11th of July. So I am able to pay the past due balance. I just probably won't be able to pay the full by the 4th of August, but I was informed that I can try to work an agreement with the landlord. I do have all my legal documentation from when my short-term disability got denied while I was on FMLA. I have my new hire paperwork. I literally have everything to show lawful cause for me to withhold the property. If I need to file that with the court, I will.
So you believe you have a lawful reason that you can withhold the property?
I do, yes. I can provide that documentation to the court. I have it all on my phone and email. If I am able to, could I email that to the court and to the attorney if need be?
Okay, so my question is, is this lawful reason an issue involving the condition of the property?
No.
Or is it the things that you just shared?
It was the things that I just shared because I was on medical leave. I had just moved and I had quit my last job and I began new employment. So I am able to take care of the back rent. I just need, I did get caught up with my utilities as part of my lease agreement because while I was out, I had racked up some debt with my car payment, insurance, and utilities. I am current on all of those. So now I can take care of my rent portion without my other legal obligations getting in the way of that. And I can get this balance paid off within a reasonable time in less than 2 months and be current with my rent. My new pay rate is $23 an hour that I make, and my previous pay rate was $16.33.
Okay, well, unless the landlord is willing to enter a conditional dismissal or a payment arrangement, What you're telling me is not a lawful reason. That means a reason that the law provides that you should be excused from having to pay your rent. What you're telling me is that you believe you have a good reason, and you were unemployed, you were on FMLA, you have a pending matter which you're a victim of, and all those circumstances cause you to be in the situation you are in now. But those aren't lawful reasons or reasons under the law that I can tell the landlord they're not owed their rent. That's why I
Oh, no.
asked you, was there issues with the condition of the property that you're alleging? Was there some constructive eviction that maybe occurred or something else that would have allowed you to have a lawful reason to claim that you should be able to hold over this property without paying? And you're saying you won't be able to pay the past due in full for another 2 months. But that's up to Mr. Joseph's client if they want to enter into a payment arrangement to give you time to catch up or not. Mr. Joseph.
Right. I do apologize for that misunderstanding, Your Honor. I am asking if I am able to just have enough time to get current, and I should be able to be current within the 2-month time frame with my new job that I began last week, just to clarify.
Okay, Mr. Joseph.
Yeah, Judge, we went over this in pretty good detail in the breakout room, and I told him my client hasn't authorized a long-term payment plan. Sometimes they do that post-judgment because they have the judgment in hand in case there's a default. And that way they don't have to, restart the process again. But I told him the best I could do is extend him beyond the statutory 10-day to that first Friday in August. Since this doesn't include August, and that's really the best that I can do under the circumstances. I'm happy to honor that, whether it's by way of a hearing decision or the consent stands, either way. But that's where we're at.
Okay, well, he's not on the record. He has not waived his right to a hearing, and
Right.
So he can proceed to hearing and present any evidence that he wants to present. The unfortunate part is I'm not in a position to hold a hearing with electronic evidence. You both will have to appear in person for a hearing, okay?
Okay.
Judge, do we know when that hearing date will be?
You don't have to start. Yeah, because the problem is we have too many hearings going on at the same time, which is why I can't do theirs right now. August 16th at 3:30.
Judge, can we have an order of escrow, given the length of time between the first hearing, which was on May 17th, and now about a month for the next one, and my client has not been receiving payments.
You can file an escrow order and I'll review and sign it.
Thank you, Judge.
Okay.
No problem.
And
Okay.
for the record, Your Honor, can you document that this Friday there will be a payment made, whether if I should pay it to the court or to my landlord as well? Because as I stated, I did just begin training with my new job last week, and I am receiving my last.
It might end up needing to be placed in escrow because they're requesting you put money in escrow pending the hearing. So you'll have, if the order is signed, you'll have to place the money in escrow here at the court. That's money that would be paid as part of this past due amount to show good faith.
I am
sir?
okay with, yes, ma'am. Thank you.
Okay.
Thank you, Judge.
Thank you. You're all set for today, Mr. Harris Green.
Thank you. Have a good day.
You're welcome. Who's on the wing tech? Do we know? They didn't respond. Who's the other one?
Morgan. Jada Horn, her case is dismissed. Tried to chat her, but she didn't.
Jada Horn.
I'm here.
Yes, your matter was dismissed.
Okay,
Thank you.
thank you.
On the no problem. On the record in the matter of Edward Rose Associates versus Essence Morgan, file number 23-00960 LT. Appearance, please.
Thank you, Judge Joe Joseph for the plaintiff.
Morgan, are you there?
Yeah, I'm here.
You need to start your video.
It says I can't, it's been disabled. It says you cannot start your video because the host has disabled it.
Okay, let's see. And so let you start now.
Yep, there you go.
Okay, you're not driving, are you?
No,
Okay, very good. Today's the date and the time set for a hearing. How are we proceeding, counsel?
Judge, we have a consent judgment that we can place on the record.
What's the term?
Thank you, Judge. It's a consent judgment for possession showing $772.21 due plus cost of $167.79, totaling $940. Writ to issue after July 31st.
Okay. Okay, Ms. Morgan, do you understand your rights as it relates to this matter?
yes,
Okay, so you have the right to have an attorney represent you in this matter. You're waiving your right to be represented by counsel,
yeah,
and then you have a right to proceed to a trial or a hearing in this matter and have the matter determined before the court whether or not you owe this judgment amount or whether or not you could be lawfully removed from the property. You wish to waive your right to trial and hearing today?
I mean, we could talk about it, but
Who's we and talk about what?
I'm confused on what you're trying to say.
What I'm saying is that you have the right to have a hearing or a trial in this matter. And so the plaintiff's attorney is saying that you want to consent to judgment entering against you for the amount of $940. So do you want to waive your hearing or your right to trial to do that?
Yeah,
Okay, is that a yes?
yes,
Okay.
yes,
Anybody threatening? Okay, anyone threatening you to get you to waive your rights today and enter consent judgment?
no,
Okay, so you're agreeing to pay the amount of $772.21 plus court costs and the amount of $167.79 for a total of $940 on or before July 31st of this year, or vacate the property by that date. Is that correct?
yes,
Okay, you have 3 business days from today. If when you leave here, you determine that you misunderstood any of the rights that you just waived in order to enter consent judgment, you can request to have this judgment set aside. We will set this matter for a hearing date. Do you understand that?
yes,
Did you give the counsel for the plaintiff permission to sign this judgment on your behalf?
I did.
Any questions for the court today, Ms. Morgan?
No,
Okay, any additional matters, counsel?
No, not on this, Judge, but I do have a quick question after this concludes regarding the time and date on the last hearing.
Okay, you're all set, Ms. Morgan. Mr. Joseph, what was the question?
Yeah, I have down the 17th, but I don't have, I didn't get the time.
Was it
16 at 3:30.
16th at 3:30.
16th, okay, well, had everything wrong, okay. Thank you so much.
No problem. Anybody else ready?
Mr. Joseph has to speak with people, but I believe Ms. Till represents about it. So
Okay, here, I'll let you handle that.
Mr. Akers, can you hear me?
Yes.
You all have an attorney?
No.
Ms. Prather, can you hear me?
Yes.
Do you have an attorney?
No.
Mr. Joseph, who would you like to speak with first, sir?
It doesn't matter. They're all at the same time, so just, whatever you wish.
You're already in breakout room number 2, so I'll add Ms. Prather to that one.
Okay, sounds good.
Did you see that?
Could I speak to the attorney for Huron Development? Or, I'm sorry, Edward Rose Associates?
He's in a breakout room right now, Ms. Till, but we'll put you in one when he's finished.
Great, thank you so much.
You're welcome.
Right.
Mr. Castillo,
Yes,
do you have Christina Castillo with you?
she should be coming in shortly.
Okay, thank you. Mr. Castillo, do you all have an attorney?
No, I don't.
Does Ms. Castillo have an attorney?
No, she doesn't.
Thank you. Just a moment.
Can I be placed into a breakout room with Miss Loudon again?
Yes. Okay. On the record in the matter of Edgewood Villas versus Desiree Henry, file number 22-03865 LT. Council appearance.
Afternoon, Your Honor. Brian Lum on behalf of the plaintiff.
And I see Ms. Henry is present via Zoom. Ms. Henry, you can hear us clearly?
Yes, I can hear you.
Okay, today was the date and the time set for a hearing. Could you mute her, please? Okay, today's the date and time set for hearing. For the court to deliver their ruling as it relates to the eviction proceeding. Plaintiff is seeking judgment in this particular case for possession and a money judgment in this amount for past due rent. I think as it reflects in People's Exhibit 1, balance owed and accruing at the time of this exhibit at least $7,827.30. The defendant alleges that she does not or should not be responsible for the past due rent because she believes she suffered a constructive eviction due to the conditions of the property. We had testimony taken on various days. This matter, testimony was presented by one witness who unfortunately did not or was not employed at the plaintiff's residential property, Edgewood Villas, during the majority of the claims being alleged, but was able to give some or shed some light into some of the questions the court had about the ledger and how complaints about conditions of property were received and addressed. And we also had testimony from a maintenance supervisor who appeared but was not able to provide much information when questioned about why people from maintenance appeared on June of 2023, June 23rd, 2023, but didn't return to complete the repairs. He testified that he was unaware why they failed to return to do those repairs, or why the issues were not fixed. So he couldn't provide much information as it relates to that, or he couldn't even address the letter from Edgewood Villas, which indicated that maintenance would be coming to her unit, the defendant's unit, on June 22nd through June 30th, between the timeframes alleged. He had no knowledge of that. What I did have is People's or Plaintiff's Exhibit 1, that is, which is a ledger. There was also a ledger submitted by the plaintiff, which referenced, and this was at the court's request, the subsidy ledger. I requested maintenance records to show when the requests were made for maintenance, as well as the rental change notices on behalf of Lansing Housing Commission. The defendant provided evidence by way of a video which demonstrated what appeared to be, to the court's view, leaks near the front door or living room area, I believe is where that was. She presented a list of housing deficiencies that was presented to the plaintiff from the Lansing Housing Commission. There's a picture of some dark black or greenish colored buildup in the ceiling area. The court's unaware of what room that is, but, and I'm not an expert as it relates to mold, but if I saw that in my house, I would presume it to be mold. And I also have a letter that was presented from the defendant from the Lansing Housing Commission for a failed inspection, and a letter from Edgewood Villas about property maintenance. I reviewed the ledgers to cross-reference, which I promised Ms. Henry I would do, to make sure that she was not charged multiple times for different months. In my review, I do not see, Ms. Henry, where you were double charged in any month. I do understand why you may have been confused by reviewing this ledger, but I can assure you, based on what I reviewed, that you were not charged twice in certain months. I did have one concern, and that was for July 1st, 2022, where she was charged or assessed a fee of $681, but her rental certificate, as referenced by the rental change notices, indicated to me that her rent should have been $636. Other than that, I didn't see any issues with the actual charges there. I did have issues as it relates to some of the late fees, and I think I stated that on the record at one of the hearings, and that would be that I would abate any rent late fees accrued during the time period from the time that Ms. Henry took possession of the property up to June 9th, 2022, because that was the time in which Ms. Henry signed a new lease, and that new lease having indicated that she would be responsible for utilities, previous lease not indicating that. And so as it relates to that, the court will make sure there's an adjustment as necessary. When I reviewed the maintenance request, because we're going to address the issue of notice to the plaintiff that there were issues. The plaintiff's first witness led the court to believe there weren't any, or all of the conditions that Ms. Henry is alleging were not reported to the landlord. I have a list of maintenance requests, which is what I asked, and I think Ms. Henry testified that maintenance requests she was able to give them either by calling or giving them in person, and so she didn't believe that all of her requests were reflected here. However, in one of the requests here, it looks like it's a work order 17052130. It was created back on 11/30/2021 at 2 p.m. That's the maintenance request that appears to have been generated by a violation from the city based on some inspection as it relates to the furnace and issue of addressing the furnace. And the inspector noted, as I read through the description, there was a condition that needed to be addressed as it relates to the water heater. And they ordered a qualified licensed contractor that's registered to the city to come and address that issue. It also indicated in that same work order, some inspector comments. It says that the access to the water heater could not be made and that they needed to have a licensed inspector repair as needed, that the wall switch is loose or missing or damaged or inoperable. The other comments was that at the base of the stairs, a switch is damaged for the light in the stairway, and that there was some water damage or drywall issues on the wall and ceilings throughout the structure. And that at the base of the stairs, the second floor toilet is loose in connection or at connection to floor tank lid is broken or missing. The flush mechanism is defective. It also says the flush mechanism, vanity, kitchen cabinet is deteriorated and damaged and or loose from the wall, and that the kitchen cabinet was deteriorated, damaged, and or missing drawers or doors. The inspector also said that their bathroom doors and drawers were damaged. This was in November of 2021, which the defendant moved into that property. It looks like just about or close in proximity to that time, maybe in September 2021. I see the notes or status, because this was listed as an emergency priority, but it only lists that it was canceled. There's no notes that provide the court with an understanding as to whether or not this was properly addressed. And it stated even in this particular, well, furthermore, the court asked or questioned the plaintiff's witness why this would state that it was canceled. And it was determined or stated that it was likely due to entry being denied. However, this was listed as an emergency or priority. And in reviewing even the information provided in this packet, it indicates that the Edgewood Villas has a policy that if there is work for an emergency purposes that needs to be done and that no one answers and or an entry is denied, that they leave a note indicating that they will enter during a certain time frame. I don't believe that when there's a description here that said there's a city violation and a city ordering them to do something immediately to bring something up to code, that they can cancel it because of being denied entry. I think that they have a responsibility and a duty to get that done. I don't have any information provided to show me that that was ever completed. Moving on to the next page that the court had concern, because I did note that the majority of the work orders that were open, it just gives me an update that they were either canceled without giving me reason why it was canceled or canceled because permission to enter was denied, meaning many of these issues which were ordered to be done in the beginning of her rental by a city inspector were not addressed. Some of these things are duplicates, duplicate issues that she's complaining about, but the inspector already gave comments about that, and so it should have been taken care of. Moving forward to one that was very concerning to me because she complains of a leak in the property and the possibility of mold. There was a work order number 1705486 created on November 5th, 2021. It says here, there's a high priority work order. It says for Edgewood Villas to inspect the unit for leaks that the current meter reads or shows excessive usage, and that they were to update this ticket with confirmation regarding if a repair was necessary or if the household appears to be using an excessive amount of water. If not home, door tag stating that you will be back between 8 to 5 on a certain date should be left. I have only indication that this work order or status was canceled, not that it was addressed. This was back in November 2021. I see here a work order from May 11th, 2023, which would have been during this eviction proceeding where a work order was initiated to require maintenance of Edgewood Villas to go through and do a walkthrough of the, mute them please, to look for issues, to see all issues that she might have, to have those addressed. I think that's also what generated or led to maintenance being sent to that property between June 22nd and June 30th to address that list, but doesn't appear, at least at the time of our last hearing, that those things had been addressed. I see a work order here, May 25, 2023. Again, it says check both doors and check the tub handle for leaking. The other request being relatively new requests. What I found to be concerning in reviewing the list of requests, because again, I'm not working with a lot of evidence provided from the defendant, but the defendant did provide a list of deficiencies. And when I compared the list of deficiencies with what was created as work orders back 2 years ago, almost in November 2021, I saw a number of overlaps. Leaking being reported back in November 2021 is still being reported as of the last court date, which is in 2023. There was issue regarding a loose toilet that was supposed to be addressed when the city inspected back in 2021. Does not appear that that was addressed. The defendant complains of concerns of mold in her house and that she didn't stay in the property because she was concerned of mold. There's noted here in the deficiency that there was a black-like substance noted in the ceiling on the bathroom. And the list intends to go on. To this date, the court doesn't have any indication that even though that Edgewood Villas received the notice from Lansing Housing that these deficiencies should be addressed within 30 days. At the time of our last hearing, we had the maintenance supervisor here, and he could not rebut or provide any clarity as to why, as of July 12th, the issues had not been addressed. And so I do believe that Edgewood Villas failed to keep this property in reasonable repair. I don't know that the condition was such that would allow an abatement of the entire amount of rent that was due, but it does require, or I think warrant some abatement, because it's completely unreasonable for you to have leaks in your property, which we all know leaks of water in properties lead to mold. But for 2 years periods of time, and for the plaintiff to make or take the position that they were not aware of any conditions, when it's clearly noted in their exhibit that they were aware that there was a leak, because the city told them, or there was at least a report that they need to address it, and that if they couldn't get access to the property because no one was there, that they need to leave a note or a door tag stating they're coming back to address it. And I don't have any records showing that it's been addressed. And then I have a deficiency notice from June of this year, which would lead me to believe it wasn't addressed because it's still a leak in the property. What I also have is a concern about this same notice saying that the usage or the meter is excessive. And when I look at her water sewer bill, it seems to just go up every month. And from what she said to the court under oath, is she's not even staying in the property. So why would her water bill be going up if she's staying with a friend because of the condition of the property? I can't, and substantially going up, almost doubling in the amount, unless she have added the amount of people, doubled the amount of people in her house or use of water for some reason, I don't see why her water bill will have doubled from the time she moved into the 2023. And then I see pictures of black mold in the, or what appears to be black mold in the exhibit she presented, as well as a picture of it. She's keeping a bucket at the bottom of the stairwell to collect water because of a leak. And so I think that it's unreasonable. I think that the landlord failed their duty to keep the property in reasonable repair, and her rent will be abated because of that. I believe that the landlord received payment for most of the time period that's being requested here from the Housing Commission, because apparently they either did not do an inspection during that time, or maybe they did an inspection and they did not find it reason at that time to address the deficiencies. I can't speak to that one way or the other. I do recognize and understand that there was a time period in 2020 and 2021 where they were not doing in-home inspection. So that could have been the issue. I can't speak to that. Neither party provided evidence to address that. But I do see where there was payment being received per her subsidy for each month up until it looks like July of 2023. Actually, it looks like July 2023, they received a payment even then. So it looks like they are receiving their payments or have been receiving payments. I'm not sure if they'll receive the next month just based on this letter of a failed inspection from June 13, 2023. However, I will be abating the amount due, subtracting all late fees. First and foremost, I will also be abating, subtracting all water sewer fees. And I originally stated I would subtract the water sewer fees that were relative to her previous lease agreement. But under the circumstances that there's been requests for a leak to be addressed and that her meter was reading excessive, and I don't have any record showing where that was addressed, every remaining water sewer fee will also be assessed, or I'm sorry, abated. In addition to that, every amount due from the plaintiff, I'm sorry, from the defendant's bill will be abated at a rate of 50%. I'm going to have to go off the record to give you a final calculation of that. In the meantime, I'm going to handle some other matters, and then I'll give you the final number. We're off the record for this in just a moment. Did you need me for something, sir? Oh, okay. Is he meeting with someone on here? Ms. Till, who are you ready on?
We are ready on Ms. Loudon. So that would have been Edward Rose Associates versus Kinshana Loudon.
Okay, we're on the record. Can you hit that there for me, please? In the matter of Edward Rose Associates versus Kinshana Loudon, file number 23-00950. Appearance, please.
Good afternoon, Your Honor. Joe Joseph for plaintiff.
Felicity Till appearing for the defendant, who is located with me via Zoom.
Okay, today's the date and the time that was set for a hearing. How are the parties going to proceed?
Your Honor, myself and plaintiff's attorney have agreed to enter into a conditional dismissal. Rent to retain is going to be $22,295.37. Court costs $167.79. Total rent to retain of $2463.16. Defendant here agrees to pay or vacate the premises on or before August 4th, 2023. I also did explain MCR 4.201 to Ms. Loudon.
Okay, Ms. Loudon? Can you unmute, please?
Yeah,
Okay, is a conditional dismissal how you would like to move forward today?
yes, please.
Okay, so you understand that you did have the right to have a hearing on this matter?
Yes,
Okay, and you're willing to waive that to have the conditional dismissal?
yes, please.
Okay, so you're agreeing to pay the amount of $2,295.37 plus court costs and the amount of $167.79 for a total of $2,463.16, or vacate the property by August 4th, correct?
Yes,
Okay, and you understand that partial performance will not satisfy this agreement?
yes,
You gotta pay in full, you gotta perform in full, okay?
yes,
Okay, so you have 3 business days. If once you leave the court, you realize you misunderstood any of the rights that you waived, you can return to the court and request to have this set aside and we'll set it for a hearing, okay?
okay.
Do you have any questions today?
I do not.
Okay, did you give Ms. Till permission to sign this document on your behalf?
Yes,
Okay, any additional matters for the record, counsel?
And I just wanted to clarify, Mr. Joseph, do I have your permission to sign and submit to the court?
Yeah, yes, you do. That's fine. That's what I was just gonna ask, if you were gonna, I didn't know if you prepared it or not, so that's fine.
Okay, perfect. Thank you. Nothing further for defendant, Your Honor.
Mr. Joseph, anything further?
No, nothing further on this case, Judge. Thank you.
Thank you. You're all set, Ms. Loudon.
thank you. Have a good day.
You're welcome. You too. Let's see here. We did. 500 acres. Okay. Are they ready to proceed?
Yeah. Mr. Joseph Hamilton.
Okay. On the record in the matter of Edward Rose Associates versus Devon Acres. Counsel of Tenant.
Thank you, Judge Joe Joseph, for the plaintiff.
Mercedes McKee is also a resident. Okay, I see that Mercedes McKee is here, but I don't think that they were named.
They are named, Judge. They are, it says Mercedes McGee and Devon Acres. I see it on my screen.
I'm talking about on your court filing.
Oh, yeah, I'm sorry. Mercedes isn't, she's an occupant, but Mr. Acres is.
Okay, sounds good. So did you meet with the parties today already?
I did, yes.
Okay, how do you want to proceed?
Judge, we've worked out a consent agreement. It's my understanding they plan to vacate, but nevertheless, we have agreed to a consent judgment of possession. There is a total balance of $2,916 that's due, plus the court cost of $167.79. That totals $3,083.79, and giving them until August 4th to vacate. Or pay, I should say, pay or vacate.
All right, judgment for possession only. Did you hear me?
Sorry?
Can you hear me?
Yes.
Yes.
Okay, that's judgment for possession only, correct, Mr. Joseph?
It is, Judge, yes.
That first, let me see, total amount being $3,083.79.
Correct.
Okay, and Mr. Akers and then Ms. McGee. Is that how you want to resolve this resolution with a consent judgment today?
Yes.
Yeah.
Okay, so you understand your rights as it relates to the eviction proceeding. You have the right to be represented by counsel. You were advised of that right back on May 17th, but you declined to meet with legal services. Did you hire an attorney?
No.
No.
So are you waiving your right to representation by counsel today?
Yes.
Okay, and then you have the right to have a trial in this matter, or you can proceed to hearing today. Did you want to waive your hearing and enter consent judgment?
Yes.
Okay. Anybody making any promises to you or threats to you to get you to waive those rights today?
No.
Okay, so you want to enter consent judgment to pay the amount of $2,916 plus $167.79 for a total of $3,083.79, or vacate by August 4th, correct?
Yes.
You understand that partial performance will not satisfy this. You understand you have to perform in full.
Yep. Yes.
Okay, you have 3 business days from today. If once you leave here, you realize you misunderstood the rights that you waived in order to enter into consent judgment, you can request to have this judgment set aside. We'll set it for a hearing, okay?
Okay.
Do you have any questions at this time?
I do not.
Did you give Mr. Joseph permission to sign the consent judgment on both of your behalves?
Yes, I did.
Ms. McGee?
Yes.
Okay. Any additional matters for the record, Mr. Joseph?
No, nothing further.
Okay, you're all set, Ms. McGee and Mr. Akers. Thank you.
All right. Thank you. Have a good day.
You too. Jasmine Crowder? You met with her already? Okay. On the record in the matter of Edward Rose Associates versus Jasmine Prather, file number is 23-00953 LT.
Thank you, Judge Joe Joseph for the plaintiff.
Okay, Ms. Prather, can you hear me?
Yes.
Okay, you're representing yourself today, correct?
Yes.
Okay, today was the date set for a hearing. Counsel, how are we proceeding?
We've talked, Judge, and we have a consent judgment that we've worked out. The rent to retain is $4,460, and the costs are $167.79. That brings the total claim amount to $4,627.79, with a writ to issue after August 4th. And a defendant has consented to her name being signed to the judgment, and I've also gone over her rights under 4.201 regarding the 3-day rescission rule.
Thank you. Can you repeat the total amount due again?
Yeah, you want me to break it down or just the total?
Total, and that's it.
Okay, $46.27.79.
Okay. Okay, and Ms. Prather, is what Mr. Joseph saying complete and accurate as to how you want to resolve this?
Yes.
Okay, and so you understand, ma'am, that you have the right in this matter to be represented by counsel. You were advised of that right back on May 17th. I can't hear you.
What did you say again?
You have the right to be represented by an attorney. Do you understand that?
Yes.
Okay, and are you waiving your right to representation?
Yes.
Can you adjust your screen so I can see your face?
What does that mean?
Okay, what does what mean? You adjusting your screen, or the question that I asked you about your rights?
The question that you asked me about my rights.
Okay, I first need to adjust your screen because I have to be able to see you while you're giving these responses, okay?
Okay, can you see me? My full entire face is in the camera.
Yes, I can see you right now. So you
Okay.
have the right to have an attorney with you today to represent you for the eviction proceeding. Do you understand that?
Yes.
Okay, and you did not hire an attorney?
No.
Okay, did you do an intake with legal services to request them to represent you?
No.
Okay, so you're appearing today without counsel. Are you waiving your right to attorney to proceed today with a consent judgment?
Yes.
Okay, you also have the right to have a trial in this matter, or you could have had a hearing, which was scheduled for today. And you can require Mr. Joseph to provide evidence to support whether or not you can be lawfully evicted from the property. Do you understand that?
Yes.
Okay. Who's knocking on the door like that? Do you want to waive your right to trial today?
Yes.
Okay. Is anybody making any promises to you to get you to waive your right?
No, I just don't want to go on trial because I'm going to make the full payment.
Okay, so you're freely and voluntarily waiving those rights?
Yes, I don't know what this means. Really, I've never been like this is my second time being on court, so I don't know this certain, like, my rights or not my rights.
Okay, I just told you what your rights were. You don't understand what I said?
No, I do. I just don't want to go through the trial process. That's what I'm trying to say.
Okay, I just want to make sure that you know that you're waiving your trial and that you know that you're waiving your right to have an attorney represent you.
Okay.
Okay, and then you have 3 business days from today's date. If once you leave the virtual courtroom, you determine or you realize you actually don't understand the rights that you just waived, you have 3 days to return to the court and tell the court that you misunderstood your rights, and then we can set it for a hearing, okay?
Okay.
You understand that, ma'am?
Yes.
Okay, lastly, are you going to give Mr. Joseph permission to sign this consent judgment on your behalf?
Yes.
Okay, any questions for me today, Ms. Prather?
Nope.
Anything from you additional, Mr. Joseph, on this matter?
Nothing further, Judge. We'll submit the judgment to the court. I believe this concludes my matters with your honor.
Okay, let's double check. You had a lot, Mr. Herman. Oh, I think I got them all. Thank you.
All right, thanks. Have a great day.
Thank you. Let's see. Someone here, oh, Mr. Wassery is here.
They want a question.
Mr. Wassery, okay, on the record in the matter of OPB Partners versus Christina and Juan Castilla, file number is 23-00974. Appearance, please.
Good afternoon, Judge Mark Wasbury on behalf of plaintiff.
Okay, and I do see Juan Castilla. I don't know why there's feedback. Mr. Castillo, are you, Ms. Castillo, in the same car?
No, we're on 2 different phones.
Oh, but are you in the same car?
No, I'm in Detroit. She's in Lansing.
Okay, sounds good. I was wondering why there was feedback, but I don't hear it anymore. Okay, Ms. Castillo, you're present, correct?
Yes.
Okay, I just sent you a request.
Yes.
I just sent you a request to start your video.
Did it go through?
It did not. Today was the date that was set for a hearing. Mr. Wassery, you're seeking an adjournment?
Yes, Your Honor. We're trying to work things out. They told me some discussions they had with management last week that I was not aware of, and I'm hoping to get to the bottom of it and work with the Costillas to solve this.
Okay, I'm gonna reset this matter. The parties need to appear in person. Whenever our next date is, that we won't be trying to do 50 million units. You can answer. a lot of things. Oh. We can do-
Can do August 9th at 2:30.
August 9th at 2:30.
Thank you, Judge.
No problem. Any additional matters for the record today?
No, thank you, Judge. Have a good day.
Thank
Thank you.
you. You too. Thank you.
All right. Bye.
Chevy. That's Mr. Chevy?
Yes.
Okay. On the record in the matter of Cedar Place Apartments versus Paul Chevy and all occupants. File number is 23-00444. Have your appearance, counsel. You can sit there, sir.
Good afternoon, Judge. Christopher Asphalt, 53129 on behalf of the plaintiff.
Thank you. And Mr. Chevy, you do not have an attorney, correct?
I'm sorry?
Do you have an attorney? No? Do you have a lawyer?
No,
Okay, this is your caseworker?
we couldn't get one.
That's fine. Here's your caseworker's here with
She's
you?
substituting on my caseworker. She's on vacation today.
Okay, sounds good.
I'm okay alone.
You're okay by yourself? Okay, I have here though that you want to do a consent order for conditional dismissal. Is that what you want to do?
I wanted to work out a deal where I pay $500 a month to pay my rent, stay. It's okay with the manager, but it's not okay with the lawyer, so.
I'm confused. It's okay with the management, but not the lawyer, Mr. Asphalt?
That's not true.
It's
Your
not-
Honor.
I was gonna say that doesn't sound accurate.
It's okay with her, it's good with her before she came in.
Mr. Asphalt, what is the agreement?
The agreement is, Your Honor, that the parties are in agreement that there's currently due and owing $3,526.70. The defendant shall pay that amount on or before August 3rd, I believe, 2023. If he fails to do that, or if he fails to vacate the property by August 3rd, 2023, then plaintiff can move without need for further court hearing to set aside this conditional dismissal, and a judgment of possession and an order of eviction can enter at that time.
Okay, you don't recall that being your agreement?
Yeah, well, what happened is I was on Aries, the Aries or something, COVID rental assistance.
Okay.
And I stopped paying the rent because I was on assistance, and they told me they would get with me to let me know when I'm supposed to start paying rent again.
Okay.
8 months went by. I didn't hear nothing. I went down to the office myself without entering. You know, when do I start paying rent? They looked in their
That's
book.
the caseworker. Ma'am, can you state your name for the record?
Heather McClellan.
Can you spell it, please?
I don't even know what happened.
LELLAND.
Did you want to help us,
Yep,
sister?
Paul, remember what you signed?
I
though?
got it.
Okay, but that's what they're wanting you to agree
You
to what
leave
you
me
signed.
alone.
Okay.
Sir, first of all, drop your hands. Don't raise your hands at anyone.
Oh, I'm not. I've
Okay.
had them up
She's-
before.
She's yeah, I recognize
okay.
that.
I'm just trying to help.
She's
remind
trying to
of
assist
what
you.
signed.
Okay, she's
Okay.
here to help. Okay,
Did you want to hear what I was saying or no?
I heard what you were saying, sir, but she wanted to assist you. So just calm
Okay,
down.
so you heard me already?
I heard what you were saying. Anything else you wanted to add?
Then my heater broke down for the rest of the winter.
Your heater broke down for the winter?
From the beginning of winter till the end of winter. They came at the end and fixed it, but the air conditioning don't work.
Okay, so your statement is that you didn't have heat all winter?
I had no heat all winter.
Did you notify them?
I notified them many times. They had different management. The management was out of the world.
Okay.
They didn't have any maintenance people. And I had floods in my apartment. At 4 different locations, I was having floods in my apartment where water is coming down from the top to the bottom. It ruined my mattress. It ruined all my blankets and towels. And this went on for months,
Okay,
the floods,
okay.
the no heat,
So did
the
you want-
water was going into the electric box and zapping it, and it got all rusted, and it was going into the actual plugins.
Outlets.
Yeah. And
Did
they
you
blew up.
want to have a hearing, sir? Or did you want to do an agreement? Because what you're saying now is that you.
I know what you're saying. Yeah, let me think.
Yeah, because what I'm saying is what you're saying now is that you believe that you don't owe them the money because they didn't take care of the property.
You know what you signed though, Paul?
I have 3 days to change my mind, correct?
Well, I haven't entered anything yet, so this isn't anything until I enter it. And I can't get you to say that you want to waive your hearing yet, so I can't enter it.
I don't know, but I have 3 days to waive the hearing.
No, you're here now to tell me if you want to waive your hearing so that you can enter into this agreement. That's what I asked you. Do you want to have a hearing or not? You can tell me today if you want to have a hearing or not. If you don't know whether or not you want to have a hearing, that's an answer for me too.
But then I don't want to lose the option of getting evicted. Not getting evicted, getting this deal.
If you want to take the deal, you can take the deal, but you would have to waive your right to have a hearing and also waive your right.
The deal won't be offered again.
No, I have authority to offer it to you now, not after we have a hearing.
So you'd have to agree to what you signed.
You can take some more time to think about it if you want and just sit back there if you want to think about it a little longer.
No, I'm good. I guess I'll sign.
You've already signed, so I just want to know, are you willing to waive your hearing?
Yes.
Does anybody
No,
promise?
I'm not willing to waive the hearing.
Oh, you want the hearing?
I don't know. I got 3 days.
You don't have 3 days, sir.
They told me I have 3 days.
No, you have 3 days if when you leave here, after this is entered and you decide that you misunderstood your rights, you can come and tell the court how you misunderstood your rights. But I'm trying to first explain to you your rights. And I'm not getting confirmation that you understand your rights or that you understand the 3-day redemption.
No, I
period.
just was on the guys, I can cancel this agreement within 3 days if I wanted to.
Well, only if you can articulate that you misunderstood your rights. I don't think that'd be a problem, but I don't think I can right at this moment get beyond whether or not you're waiving them now. That's the issue I have now. It doesn't sound like you're waiving your rights.
You understand what she's asking you right now?
So what does that mean? No?
No, you have to tell me if you wanted to waive your rights or not.
I don't want to do it right now. I want to have my 3 days.
You want 3 days to think about it? Is that what you're
Think
saying?
about it, yeah.
Okay. I can give you 3 days to think about it.
What?
I cannot give you 3 days to think about it. I can set it for a hearing. That'll be your time to think about it.
Then you don't take my thing away, right? My deal away?
Right, yes, Paul. The option of having a conditional dismissal is if you want to take it now. If you don't want to take the conditional dismissal, then we can have the hearing. And I would ask the court, if I prevail and the court rules in my favor, then I will ask for a judgment of possession
I
and
know.
subsequently an order of eviction.
We had,
Sir,
the
did you meet
manager
with
is
legal
okay with
services
me
when you
paying
came before?
$500 and he
Yeah.
got to pay you.
He did not meet with
They
legal.
did not follow up. They talked to him one time and my coworker tried multiple times to get legal aid to respond to assist today and she had no success.
Can you contact Ms. Till, please? Because I think he needs an attorney. I don't know if legal services will be able to represent you, but they should have at least gotten back with you.
Should have.
Cause I thought that, well, I do have now, I know this is true. I got 10 days to pay it off still. Right, to pay this debt off.
That's what they said.
Well, this is an agreement
And
that you're
stay,
gonna
right?
pay, you're gonna pay or move by August 3rd.
I got 10 days to pay it off.
Yeah, more than 10 days. You have until August 3rd.
August 3rd, 2 weeks.
And Your Honor, just for the record, according to my notes, when we appeared on May 24th, that he asked to speak to legal aid then, and I believe you put him in to a breakout.
Correct. What she's saying is that they were supposed to get back with him and they didn't. I just want to confirm if they had determined they were not going to represent him.
Very good.
So we can have Ms. Till log back in. She was here. and explain or let me know one way or the other. You have a seat and I'll call your case back in a couple minutes, okay? Rachel Gaines is in the wait for the breakout room. Who's she meeting with? I don't see. Interesting. Bean. Or Ben. Okay. Rachel Gaines. Rachel Gaines is Mr. Ashcroft.
Yes.
Mr. Asphalt, I believe, is for.
I'm sorry. Ben. Okay, who is representing, what happened to the attorney? Is the attorney in person that was here first?
He was on Zoom, put in the breakout room, and I don't know.
Ms. Gaines, did you meet with the attorney? She on our device?
I do not have the attorney.
Did you meet with the plaintiff's attorney?
Is that the guy that just came and took me to this room?
No, that would not be. That was my court officer.
No, I have not met with nobody.
Okay, can you bring her in here? I don't know where the attorney went.
Was it Brent's attorney?
Did you meet with an attorney today?
I just spoke with somebody on Zoom. I don't know if it was an attorney.
Okay, can you come in the courtroom, please?
Yes.
Click the red button to leave meeting.
Ma'am, you can come right here. They can have a seat. Yep. Okay, you met with an attorney?
I believe it was it Brent's attorney? I know I just spoke to somebody.
And it was about the eviction?
Yes.
Okay, and did they tell you to come back into the main courtroom?
Somebody just told me to come in here.
That's my court officer.
Yeah,
He told you to come in here. The person you met with.
On the phone, no, he told me to hold on 1 second while he switched over to speak to Brent about, because I have somebody going through pain.
Well, he's not, that attorney is not here, and I don't know what happened to him. Did he meet with Ms. Walls? No.
I only put him in a room.
Okay, well, we were scheduled for 3:15. I don't know what happened. If you can have a seat there, if he's not back by 4 p.m., I'm dismissing the case. You can have a seat back there. I'm back on the record in the matter of Paul Shebley. Mr. Shebley, did you think about it again? Mr. Shebley, you thought about it?
Yep,
You want to take the conditional dismissal?
I'm gonna dismiss it or whatever. Not dismiss it, I wanna take the deal.
Okay, so that's the deal. The deal is that they're going to dismiss the case today.
Right.
And that you agree to pay the amount in total of $3,526.70 on or before August 3rd.
Yep,
Okay, that's the deal you want to take?
yep,
Okay, so you understand that you had to give up your right to have a trial in order to take this deal. You understand that?
yep,
Okay, and you have to give up your right to be represented by counsel to take this deal. You want to do that?
yep.
Okay. Anybody threatening you to do that? Anybody threatening you to take this deal?
No.
Any promises being made to you if you take this deal?
No.
Okay, you do have 3 business days. If once you leave here, you realize you misunderstood those rights that I just told you you had to give up, you can come back and ask to have this deal set aside, okay? Is that a yes?
Yes.
Okay, and then you understand that you gotta perform in full, so that means you have to either pay the entire amount in this deal, or you have to vacate by the 3rd of August. You understand that? Is that a yes? Is that a yes?
Yes.
Do you have any questions?
What happens if I don't move out by the 3rd?
Then they're gonna send the court a document and ask if they can evict you because you entered this deal saying
How
that
long will that give me?
they'll be able to get it right after that date, after August 3rd.
How long?
They can request a piece of paper that they can use to remove you after August 3rd.
It'll be on there?
It
How
will,
long I have?
no, you have until August 3rd.
If I stay, it'll be like a 1 day get out.
They can come on August 3rd and request a writ if you don't do what you're supposed to do.
Get out 1 day.
They'll have to file it to get you out of that, but you should in your head think August 3rd.
Okay.
Don't try to look for extra days.
Oh,
You
no,
understand that?
I just wanna know my rights.
I told you your rights. Your rights is that you have the right to have a trial. And your rights is also that you have the right to be represented by a counsel. And you are agreeing to vacate this property and they'll dismiss the case by August 3rd, which is more than what the statutory time frame would have been if you had a hearing. If you have a hearing today, and let's say you tell me your side and he tells me his side and his client wins, you wouldn't get until the third. You would get until July, is it the July 31st. You get about 3-4 extra days by this agreement, okay?
Okay.
Any other questions?
No.
Okay. And you've signed this document here?
Yep.
Okay. If you hang tight, we'll get you a copy of this and then you'll be all set, okay?
Yeah.
Any additional matters, counsel?
I'm sorry, Judge, did you say any other matters? I see Mr. Ben, he's one of my 330s, I believe.
Okay, sounds good. We'll get you in a private meeting room with him.
Okay,
Here goes
thank
the attorney Strickler. I'm not sure what's going on here. Mr. Strickler, did you get lost? We were waiting for you.
I apologize, Your Honor. I had to call to confirm with my client about the offer we were making to Miss Walls, and I think it must have dropped the Zoom. I apologize for that. But I did have a chance to confirm with my client that he was willing to enter into a conditional dismissal with Miss Walls if the court wanted to proceed.
Ms. Walls, you can come up here.
Gaines, that's Ms. Walls up there.
I'm sorry. Did you meet with Ms. Gaines?
I have not met with Miss Gaines yet. No, just Miss Walls.
Okay.
Me and him just spoke on the Zoom.
She said she spoke to you.
On Zoom.
Okay, maybe I got them confused, Your Honor. I apologize. I spoke to one of them so far, but not the other one. I thought it was Miss Walls.
Okay, I don't think you spoke to Ms. Walls. She's shaking her head no. I think Ms.
Okay.
Walls is also driving while she's in court. She's trying to get pulled over and get a ticket.
Yeah, okay, then I didn't speak with Miss Walls, Your Honor. It was Miss Gaines. I apologize.
Okay, sounds good. Ms. Walls is gonna be removed until she's not driving, because I know she knows there's a hands-free law, number one. I also know she's in court. And we don't want to get traumatized if she's in an accident on Zoom. Ma'am, you can come here because he met you. Okay, we're on the record in the matter of, this is Gaines. Del West Homes and Brett Robbins versus Rachel Gaines. File number is 23-00982. Can I have your formal appearance for the record?
Brian Stiller on behalf of the plaintiff, Del West Homes, Your Honor.
Thank you. And then I have Ms. Gaines present here in the courtroom And you don't have an attorney, correct, ma'am?
No, ma'am.
Okay, so she met with you privately in the Zoom room, and you all have entered into conditional dismissal or worked out a conditional dismissal?
I believe so, Your Honor. Gaines.
Can you place the terms on the record?
I'm sorry, Judge?
Can you place the terms on the record?
Yes, Ms. Gaines said that she's going to be receiving some assistance from a program that will allow a payment of $4,500 to the plaintiff. And we really accept that prior to, I believe the court has been using August 3rd as the date. So then the total would be the $4,500 payment plus $167.7 court costs for a total of $4,667.79.
Okay. And that's correct, Ms. Gaines? Okay, what's the program that you're doing?
Capital area housing. And then there was another CB, let's see. Am I allowed to put my phone out?
Yes.
So it was capital area and then MSHDA.
Commissioner?
Yeah.
Okay, sounds good. So you want to enter a conditional dismissal? That means you want to waive your right to be represented by counsel today. Is that correct?
Yes, ma'am.
You also have the right to have a hearing or a trial on this matter. Do you want to waive your right to a trial?
Yes, ma'am.
Okay. Anybody promising you anything or making any threats to you to do that? Okay, so you want to enter dismissal. The matter will be dismissed today, and you agree to pay the amount of $4,500 plus court costs of $167.79 for a total of $4,667.79. You're agreeing to pay that or vacate by August 3rd, correct?
Correct.
Okay. You understand that partial performance of this agreement will not satisfy. You have to either pay that full amount or you have to vacate by August 3rd. You understand that?
Yes, ma'am.
If you don't, then the plaintiff has the right to request a writ of execution and immediate judgment to enter against you. You understand that?
Yes, ma'am.
Okay. You have 3 business days. If after you leave here today, you realize that you actually misunderstood the rights you just told me you understood, you can request to have this set aside. You would have to come to the court within 3 business days and request to have this set aside, okay? Is that a yes?
Yes, ma'am.
Okay. And lastly, did you give Mr. Spittler permission to sign the conditional dismissal on your behalf?
Yes, ma'am.
Okay. Do you have any questions?
No.
Any additional matters on this record, Mr. Spittler?
No, Your Honor, thank you.
Thank you. You're all set, ma'am.
Thank you. Come on.
Here, Potter. Here with Mr. That's Mr. Asphalt is not all of those. Okay. Ms. Walls, we need you to start your video and unmute your device. Okay, are you in a safe location, not driving?
Yes.
Okay, do you have an attorney?
No.
Okay, I'm gonna put you in a private meeting room with the plaintiff's attorney to see if you can resolve this, okay?
Okay.
Okay, and Mr. Spittler, do you want your client to accompany you?
He doesn't have to. I've already spoken with the Your Honor, but thank you.
Okay, sounds good. You can put them in a private meeting room. Pittman needs to meet with him. I'll be right back on this one. back on the record in the matter of Edgewood Villas versus Desiree Henry.
Here.
Okay, I've had an opportunity to calculate the water fees, and I calculate a total water fee accumulation of $1,866.88 that will be abated. I found a discrepancy in the amount for her July 1st, 2022 rent, and that was according to the document submitted from the plaintiff per the court's request as to what her rent should have been as of July 1st, 2022. It should have been $636. I see where she was assessed a amount of $681. So I'm subtracting $45 just for that purpose. Then there is a total of 13 late fees I calculated on the lease, the ledger I have, for an amount of $600.
What the hell? Hello? What the hell happened? Oh my God. Shit, I can't hear her. Hello? Hello? Oh, okay. She dropped off the Zoom call.
Sorry, we timed out on Zoom for being on here for too many hours. Mr. Lumber, you have any idea as to whether or not the issues were addressed as it relates to Lansing Housing Commission?
I believe they were addressed, Your Honor. There was 1 month they abated it, I think, on the housing assistance ledger, and then they started paying again.
Okay, and so, Miss Henry, are you out of the property yet?
I have not moved my things out of there, no.
Okay, well, you're gonna need to remove your things from the property, and I'm gonna actually give you until August 4th to do that.
Okay.
You'll vacate by August 4th, and judgment the plaintiff. Let's see here. Who's your court costs? Mr. Lum?
Give me a moment, Your Honor. I did not file this case, Your Honor. This was filed by Mr.
Cyber.
Yes.
possession judgment will enter for the amount stated, $2,632.71. For a vacate or writ date of, okay, I think I have here that there was a filing fee of $130 plus service fee of $36.56. So a cost of $166.56. That's for possession judgment only. I'm denying the request for the money judgment.
You're cutting out, Your Honor. Could you repeat that, please?
I'm not sure. That was for possession judgment. The amount would be $2,632.71 plus $166.56 for court costs. $2,799.27 is the total for that judgment. There was a supplemental claim for money damages, but I'm gonna let that claim continue because once she vacates the property, you need to inspect it, find out what's going on in there. I can't, it says to be determined. I don't have anything right now to determine.
Okay.
Okay, so money judgment will continue, possession judgment, and the amount stated on the record. And Ms. Henry needs to vacate by August 4th, where she can pay that amount and stay if that's what she wants to do. Any questions?
No, Your Honor, thank you.
Ms. Henry?
You said I have till August 4th to
August
pay
4th,
the
that's correct.
2,700 and what?
And $99.27 or vacate the property by August 4th.
Okay, and then like, so with, all right, that's fine. I was about to ask about the Lansing housing thing.
But what about the Lansing housing?
I was gonna say like, so if I just pay them and just move, I can still move out and take my voucher with me.
Yeah, you need to contact your housing coordinator. I don't know. Mr. Lum said he believes the issues were addressed, but you need to talk to them and let them know that you need to move. I don't see why you would, based on what you reported as the history you had in this property, why you would want to continue living there, but that's up to you.
No, I don't want to live there. I'm stating that I want to take it and I want to move. I want to move like with my.
You need to talk. Yeah, you need to contact Lansing Housing Commission about that. Okay.
Okay, sounds great.
Okay, no problem. Mr. Lum, can you provide the court with a order under the 7-day rule?
Yes, Your Honor, thank you.
Thank you. You're all set, Ms. Henry.
Alrighty, sounds great. Thank you.
Thank you.
Bye-bye.
Mr. Spitler, were you all set in the breakout room?
I was, Your Honor. Yes, thank you.
Okay, 1 minute, moment. This file. On the record in the matter of Del West Homes LLC and Brett Robbins versus Shinoria Walls, file numbers 23-00983 LTE. Appearance, please.
Brian, on behalf of the plaintiff, Del West Homes and Brett Robbins, Your Honor.
Okay, and Ms. Walls is present without counsel today. The parties did meet. Mr. Spitler, how are you proceeding?
We have agreed to enter into dismissal with Ms. Walls. Apparently, she has the other tenant with the cabinet housing, I believe, and the amount that she would be $4,800. So including the court costs of $167.79, she agreed to pay $497.79 by August 3rd.
I don't know if that was his computer or if it's ours. Was it going in and out for you? Okay. Ms. Walls, was that a complete and accurate understanding as to how you want to resolve this?
Yes.
Okay, so you understand that you have the right in this matter to be represented by an attorney?
Yes.
And you also have the right to proceed to a trial in this matter or a hearing. Your hearing was scheduled for today. Do you understand that?
Yes.
Are you willing to waive your right to be represented by counsel and your right to have a trial in this matter in order to enter into a conditional dismissal?
I'm sorry, can you repeat that?
Are you willing to waive your rights that I just asked you if you were aware about in order to enter into conditional dismissal?
Yes.
Okay. Anybody making any threats to you to get you to waive your rights and enter into this dismissal?
No.
Okay, was there any promises being made to you to get you to want to waive your rights?
No.
Okay, so you're agreeing to pay the amount of $4,800 plus court costs in the amount of $1,067.79 for a total of $4,977.79 on or before August 3rd, or vacate by that date, correct?
Yes.
Okay, partial performance will not satisfy this agreement. You got to pay in full or vacate by that date. Otherwise, the plaintiff can request an immediate judgment against you and get a writ to remove you from the property. Do you understand that?
Yeah. Yes.
Okay, so you have 3 business days from today. If once you leave here, you realize you misunderstood the rights that you had to waive in order to get the conditional dismissal, you can request to have this set aside and then we'll set it for a hearing, okay?
Okay.
Do you have any questions?
No, ma'am.
Are you giving Mr. Spittler permission to sign this agreement on your behalf?
Yes.
Okay, any additional matters, Mr. Spittler?
Oh, Your Honor, thank you.
Thank you. You're all set, Ms. Walsh. Be safe.
Have a good day, Judge.
Thank you. Ms. Walsh left already? Okay. Ms. Till?
Yes, Your Honor.
You didn't message her? Ms. Till, I thought we sent you a message. We actually was having you come back because we had a gentleman who thought that he reached out to you, Mr. Shebley.
Yes.
But that he had not heard back, but he later decided he was going to waive his right to counsel and enter conditional dismissal.
All right. Thank you, Your Honor.
No problem. Thank you.
Thank you.
Who?
I did, for whatever reason, she keeps coming back.
Pittman? Oh, yeah, it says you're in there. She's sitting in there now. He met with Ben already? So we're just waiting for Ben. She's in the breakout room. She's in the breakout room. Were you all set with Ben and Potter?
Yes.
We can handle them and then you can go through them. They've been waiting. Okay, we're on the record in the matter of Woodbridge Apartments versus Byron Ben, file number 23-00992 LT. Appearance, please.
Christopher Ascroft on behalf of the plaintiff.
Okay, Mr. Ben is present via Zoom without an attorney, correct, Mr. Ben?
Yes, ma'am.
Okay, counsel, how are we proceeding?
Your Honor, we have the terms of a consent judgment that I'd like to put on the record.
You can proceed.
The parties are in agreement that there's $5,586 in rent, $155 in court costs for a total amount of $5,741. Defendant must pay $1,000 by 7/28, $1,200 by 8/11, $1,200 by 8/25, and the balance And I'm sorry, Judge. Yeah, the balance due and owing of $2,341 plus August rent and late fee by 8/31. If the defendant fails to make either one of those payments, then a writ can issue.
Okay, can you approach with that, please? Mr. Ben, is that accurate as to how you want to proceed?
Yes, ma'am.
Okay, so you understand, sir, that you have the right to be represented by an attorney in this matter?
Yes, ma'am.
Are you waiving your right to representation today?
Yes, ma'am.
You also have the right to have a trial in this matter, or you can proceed to hearing today. Are you waiving your right to trial?
Yes, ma'am.
Okay, anybody threatening you or making any promises to get you to waive those rights today?
No, ma'am.
Okay, so you want to enter into a judgment by consent, and you agree to pay the amount of $5,586 plus court costs of $155 for a total of $5,741, or vacate by July 31st, 2023. You agree also that you will pay $1,000 by July 28th. You're going to pay $1,200 by August 11th, and you're going to pay $1,200 by August 25th. It says $2,341 plus August rent.
And late fee.
Okay, and late fee. It says $798. Is that what that says?
Yes, that's the total amount.
Okay, by August 31st, or writ will issue. Is that accurate, sir?
Yes.
You have 3 business days from today's date. If once you leave the virtual courtroom, you realize that you misunderstood any of the rights that I just went over with you, you can request to have this judgment set aside, and we'll set this matter for a hearing, okay, sir?
Okay, ma'am.
Okay, are you giving us permission to sign this judgment on your behalf?
Yes, ma'am.
Do you have any questions?
Not at this time.
Okay, any additional matters for the record?
No.
Thank you, you're all set.
Thank you.
You're welcome. On the record in the matter of the people, I'm sorry, we're still on Simmons. On the record in the matter of Woodbridge Apartments versus Kiera Potter, file number 23-00993.
Chris Frass, spoke on behalf of the plaintiff.
Okay, Ms. Potter, are you still there? Okay, Ms. Potter might not be available. Carter, are you available?
Yes, I'm still here.
Okay, I sent you a request to start your video. Okay, very good. Okay, and you don't have an attorney, correct, Ms. Carter?
Correct.
Okay, today was the date set for hearing. How are we proceeding, counsel?
Your Honor, the parties have come to the terms of a consent judgment. They are as follows. There's currently rent due and owing of $2,623.48, court cost of $155, total amount $2,778.48. The defendant shall pay that amount or vacate by August 4th, 2023. The defendant must also pay August rent of $708 by August 4th, or a writ can issue.
Okay, you can approach with that. I don't know why Joppa was here. I just wrote him. Oh, okay, very good. Okay, Ms. Potter, is that an understanding as to how you want to proceed?
Yes.
Okay, so you understand first that you have to give up your right to be represented by an attorney in order to enter into consent judgment today?
Yes.
Okay, you also would have to give up your right to have a trial or hearing in this matter. Do you want to waive that today?
Yes.
Anybody threatening you or making promises to you to get you to waive your hearing?
No.
Okay, so you want judgment to enter by consent, and that is for you to pay the amount of $2,623.48 plus court costs in the amount of $155 for a total amount due of $2,778.48, or vacate the property by August 4th, 2023. It states here, the court will further order that the defendant must also pay August rent of $708 by August 4th, or a writ can issue. Is that accurate, ma'am?
Yes.
Okay, you have 3 business days from today's date. If you leave here and you realize that you misunderstood the rights that you're waiving in order to enter into this consent judgment, you can request to have the judgment set aside, and we will set this matter for hearing. You should also understand, ma'am, that partial performance will not satisfy this. You must perform or pay in full. Do you understand?
Yes.
Do you have any questions?
Not at this time.
Are you giving the court permission to sign this consent judgment on your behalf?
Yes.
I'm sorry?
Yes, ma'am.
Okay, you're all set unless you have a question for me.
Thank you.
No problem. You can, if you want to log back on, I put her in the waiting room because she was laying down.
Okay.
Let's see. Okay, Jakira Pittman. You're muted.
I'm right here.
Okay, if you want to go back into the breakout room, we're gonna put Mr. Asphalt in there. You should stay in the breakout room until you finish speaking with him, and then you can return to the virtual courtroom, okay?
Okay.
Put her in room 4.
Okay. My phone, like, will you send me another invite, or
Let's see.
usually when I'm on my computer, I just, yeah, there it is, Judge, thank you. You send me to 1, is that what you said?
Yeah.
Okay.
Over here.
Hmm.
On the record, in the matter of Woodbridge Apartments versus Shakira Pittman, and this is file number 23-00994. Council appearance.
Christopher Asphalt for the plaintiff.
Okay, Ms. Pittman, I need to see your face. Okay, today is the date that's set for hearing. I do have a consent judgment here. It says that the defendant is agreeing to pay the amount of $7,762 plus court costs, $155 for a total of $7,917 or vacate by August 4th, 2023. Is that accurate, Ms. Pittman?
Yes.
Okay. And so you understand that before you can enter into a consent judgment, you have to give up the following rights. First, you have the right to be represented by an attorney today. Are you waiving your right to be represented by counsel?
Yes.
Okay, you also have the right to proceed to a trial or a hearing in this matter. Your hearing was scheduled for today. Are you willing to give up your right to trial in order to enter into judgment by consent?
Yes.
Okay, anybody threatening you or making any promises to you to get you to waive those rights that I just listed to you?
Yeah.
I'm sorry?
Say that again?
Is anybody threatening you or making any promises to you to get you to waive the rights that I just told you about?
No.
Say that again?
No.
Okay. You have 3 business days from today. If you leave the courtroom and you realize that you misunderstood the rights that you just gave up, you can request to have this judgment set aside. You would have to articulate to the court how it was you misunderstood your rights, okay?
Okay.
Okay, partial performance on this judgment will not satisfy. So that means you have to either have to pay the full amount or vacate by that time. You recognize that?
Okay.
And do you give the court permission to sign this on your behalf?
Yes.
Okay, do you have any questions?
No.
Okay, you're all set. Thank you. Thank you. Why does Mr. Jaffer keep logging in? What's happening?